Veuillez vous lever. Cha soom chênh coi cho. Please sit down. Veuillez vous asseoir.
The President, from now on, the hearing will be conducted in open session, so I would like the AV and the audio unit to connect this audio and visual system back to the public gallery. I now would like to give the floor again to Judge Civil Cartwright to lead on the discussion. The floor is yours. Thank you.
Thank you, President. As the President has indicated, we have now completed the closed session. That session was conducted in the absence of the public to preserve the rights and security of witnesses who the trial chamber wished to discuss with counsel. I now turn to a preliminary witness list for the trial. The trial chamber has taken into consideration the witness lists filed so far and the observations of the parties, and it would like now to inform the parties of its decision concerning the witness list for the trial. In accordance with Rule 80 bis 2 of the rules, where the Chamber considers that the hearing of a proposed witness or expert would not be conducive to the good administration of justice, it shall reject the request that such person be summoned. In determining whether this is the case, the Chamber has evaluated the proposed hearing of witnesses and experts in the light of Rule 87.2 A, B, C and D. It considered whether the proposed testimony would be irrelevant or repetitious, impossible to obtain within a reasonable time, unsuitable to prove the facts it purports to prove, or not permitted under the law. Among other criteria, and in order to avoid unnecessary repetition and lengthy hearings, the Chamber can take into consideration the situation where several witnesses intend to give evidence on the same facts. The Chamber has also considered whether the parties have agreed on facts. Testimony that is related to agreed facts may not be necessary. Finally, the Chamber notes that it needs complete contact details for each witness in order to summon them. It is for the party which requests a witness to be summoned to provide the exact address or enough information for the Chamber to be able to locate him or her. The Chamber would like to note that the need to hear a witness may change during the course of the proceedings. The Chamber needs more time and information to decide on the acceptance of certain witnesses. It is therefore wise and conducive to the good administration of justice to decide tentatively on a certain number of witnesses now and to issue a final decision on the remaining witnesses at a later stage. Where appropriate, the witnesses are listed in alphabetical order, in English and French. The Chamber will announce the tentative calling order of witnesses at a later stage. The first list concerns those the Chamber has decided to accept. That list is as follows. Witness KW 29, Nayan Chanda, David Chandler, KW 22, KW 25, KW 06, KW 23, witness D4, witness CP25, witness Nick Dunlop, witness CP26 or A05, witness KW09, witness D5, expert KW34, witness CP24 or A04, witness KW13, KW11, KW18, KW21, KW19, KW08, KW12, KW16, KW17, witness D6, KW27, KW10, KW15, KW20, expert Françoise Sironi-Guibar, witness D1, KW07, KW24, witness D2, D3, witness KW28, witness KW01, witness CP7 or A06. The Chamber has decided to postpone its decision whether to hear the following witnesses. Witness KW04, KW03, CP29, Craig Etchison, Richard Goldstone, Stefan Hessel, Raoul Mark Jenner, witness CP23 or A03, witness D9, Christopher Lepel, witness CP22 or A02, witness KW14, witness D8, witness CP21 or A01, witness Marie-Claude Gibard, witness CP210, CP33. In relation to witnesses CP23, CP22 and CP21, Council will be given the opportunity to comment in writing. We have decided to postpone all witnesses on the list filed by Civil Party 1. During the closed session, there was argument concerning 3 witnesses, witnesses KW 30, 31 and 32. They are witnesses who are sought to be summoned to discuss practices at M13. The trial chamber announced its decision in relation to these 3 witnesses in closed session and now repeats that decision in public session. The trial chamber considers that the practices at and the development of S21 are pivotal to this trial. The President and the trial chamber judges have decided that the 3 witnesses on the co-prosecutors list, witnesses KW 30, 31 and 32, may well assist them to ascertain the truth concerning the allegations against the accused by giving testimony about the degree of the accused's knowledge of the development of security systems in democratic Kampuchea and at S21 in particular. During the closed session, the trial chamber also mentioned one witness that it considered would be appropriate to call. That is, a witness called by the trial chamber itself. It now announces that it will call the witness whose name was referred to in private session but who has not yet undergone a risk assessment. This witness has been assigned the pseudonym TC1 and will be called by the chamber. The chamber will now comment on requests to hear witnesses that it has decided to reject. The Council notes that according to Rule 80 bis 2 of the rules, where the chamber considers that the hearing of a proposed witness or expert would not be conducive to the good administration of justice, it shall reject a request that such person be summoned. The chamber refers to the witness list filed by Civil Party 2 and in particular witness CP28 or A07. The chamber notes that it has been provided with no information confirming that she is a relevant witness. Namely, it has no information that she was imprisoned at S21. It further notes that in spite of its request, the civil party lawyers have provided no further information concerning the contact details of witness CP28 or A07. The chamber therefore concludes that the whereabouts of this witness remain unknown. In the absence of any means to locate, contact or summon this witness, the chamber is not able to call witness CP28 or A07 to testify. The chamber therefore considers that the evidence which could have been brought by that witness is impossible to obtain within the meaning of Rule 87(2). Consequently, the chamber rejects the request by Civil Party 2 to hear witness CP28 or A07. The chamber now refers to the witness list filed by Civil Party Group 3 and in particular witnesses CP31 and CP32. In the direction requesting further information in preparation for the initial hearing issued by the trial chamber on the 5th of February last, the defence was asked to indicate whether it contested any of the facts these 2 witnesses propose to testify about. The Chamber acknowledges receipt of the response from the defence filed on the 12th of February 2009 and notes that it does not contest the facts that these witnesses intend to testify about. The Chamber further notes that the estimated length of testimony for each of these witnesses is 10 minutes. We have received confirmation that the evidence that these witnesses would testify to is uncontested, and therefore the Chamber concludes that it is unnecessary to summon these two witnesses. Finally, in this part of the initial hearing, I want to return to a discussion that was held during the closed session. This discussion concerned the witness list for Civil Party Group 1, and the counsel for that group made specific comments concerning one of the witnesses, which drew responses from counsel for the defence and from Maître Sieur. I want to give the opportunity to those counsel to comment again on the matters raised, because the trial chamber considers that they are important matters for the public to hear in understanding the scope of these trials. However, I want to impose a time limit on the comments and hope that each of the three counsel I have mentioned will confine their remarks to 5 minutes. And Mr. Petit has indicated that he wishes to comment, as has Ms. Studinsky. Hopefully, by the time the three previous counsel have commented, they can confine their remarks to a much shorter duration of approximately 2 minutes each. Thank you. Mr. Khan, do you wish to open the discussion?
Your Honour, with your leave, perhaps the more appropriate with respect to procedure, if you're so minded, would be to follow what happened in closed session.
Of course, Mr. Khan, I'll do that.
Okay.
Monsieur Roux, would you wish to begin? That will mean that you will have to explain a little bit about the witness concerned, without, of course, referring to any names, because although confidentiality is not requested, we have taken the view that until a risk assessment is completed, no names will be mentioned. Thank you, Maître Roux.
Merci, Madame le juge.
Thank you, Your Honour. The defence earlier on reacted specifically on the issue of witness 3 in the list submitted by the civil parties team of lawyers, group number 1. That team was requesting that witness number 3 be summoned to assist the court in the determination of the appropriate sentence, upon which the court would make a determination vis-à-vis the accused. Your Honour, President, Your Honours, we have on several occasions already had opportunity to emphasize the fact that in this hybrid tribunal, which is both national and international in nature, we are creating jurisprudence. We are the first international tribunal that accepts as such the presence of civil parties. as participants. There are undoubtedly victims that are present nowadays in the Lubanga case that are present at the International Criminal Court, but they don't have the same rights and entitlements as here. They can only express their concerns, and they can only do so after being duly authorized to do so. They are not civil parties, and this is motivated by a very straightforward reason. That tribunal, this tribunal, is the only one where the procedure applied is a civil law procedure, which thus allows for civil parties. In a civil law procedure, civil parties are part and parcel of the process. They are participants in hearings. As far as I'm concerned, as an international lawyer, I have for years fought for it to be possible for victims to have a voice in international trials. And I'm deeply pleased to see that victims, as civil parties, can take part in every respect in hearings, that they have the authority to summon witnesses, that they can take part in debates, that they can ask questions themselves directly or via their lawyers, specifically directing questions to the accused in particular. All of this either in their direct capacity or via their lawyers enables them to express the tremendous suffering that they or their relatives and close loved ones have experienced. The voice of the victims is crucial. We shall be in a position to hear and to respect the suffering of the victims. This being said, what exactly is the role of a civil party in a trial of the Roman-German tradition? It is very clear for all authors concerned that the civil party and the prosecutor are different. They have different functions and roles. The civil party is present in its capacity that enables it to express its suffering and to seek redress, to seek reparation. But in terms of the social provision of reparation, the co-prosecutors are in charge of this particular function. The co-prosecutors will speak on behalf of the public opinion of society in order to require a sentence to be applied. This is never the role of the civil parties. To give this role or right to civil parties, that's to say the right to claim a particular sentence, would amount to regression in our jurisprudence, because it would bring us right back to the days of direct revenge. All authors tell us that the separation between the functions of civil parties and prosecutors is essential in terms of the civil parties allowing the prosecutor to take on board the depth of their suffering and to translate this in terms of a sentence to be formulated. I think I can leave my points at this point, but I would like to suggest now to the court to summon an expert who is possibly the leading world expert on this subject, and I'm referring to Professor Robert Badinter, former French Justice Minister, the person who has no doubt done the most to introduce new rights for civil parties in criminal cases when he was the Justice Ministry of France. Robert Badinter was also the originator of the abolition of the death penalty in France. He also did very, very much to promote the role and voice of victims in criminal proceedings. He was also president of our Constitutional Council in France. He is a teacher of law in the USA, which means he is also very much conversant with common law. Nowadays, Mr. Badinter is publicly stating his concern about an undue extension of the role of civil parties. I think today Mr. Badinter would be the best expert to establish for us certain lines of conduct and ideas for us to ponder as to what exactly we should be doing. On this issue, I think it would be extremely worthwhile for this court to listen to the point of view of Mr. Badinter. Thank you, Your Honor.
Thank you, Maître Roux. Now, Maître Sieur, do you wish to comment? And remember, I did indicate 5 minutes. It would be very helpful if you could be succinct. Thank you.
Madame le
Mr. Sieur, Your Honor, Your Honors, we have the very strong impression today that we are taking part in the writing of international criminal law for the future, insofar as the victims' participation in trials is concerned. Before I indicate that Mr. Roux's view tallies with mine, that we are in perfect agreement, in order to clarify matters, I would like to let the court know that victims are represented by a group of lawyers which is united, which is a solid whole in bearing the suffering of the clients who have honored us by asking us to represent them. The word lawyer comes from the Latin advocare, so we are speaking for the pain of our clients. This should not, at this point, raise any difficulties. We should not consider that because there is a minor disagreement in limine litis at the beginning of trial, we are raising questions as to how we are going to perform our role or as civil parties, that is our technical role in these proceedings. Before this court, we have this role to play because this is a hybrid court. It is based on United Nations or international criminal law and Cambodian law. And Cambodian law means that it is based on the Romano-Germanic system. And it is this Romano-Germanic legal system that allows victims to join as civil parties. And this is what we do before the courts in France. And I should say that Article 23(1), which the Judge Lavergne referred to, is largely similar to the definition of the role of civil parties in France. That is a double role
to seek vindication by participating in the prosecution with regard to the elements of the crime. But behind the prosecution, only with material elements, and therefore we are the active witnesses. We are parties, witnesses who are parties in the proceedings, who have to provide these material elements by giving testimony in an active way under the law, so that the elements of the crime can be determined. That is the first point. With regard to the second point, we seek reparations. We do not seek punishment. Reparations pertain to the party, to the victim, because punishment is part of another system. Your Honors, punishment is defined by 4 factors. You lock someone up, you punish him so that other people may not do that, and this is part of public order. That is the job of the prosecution. The second function of punishment is to isolate someone, the dangerous person. That is not the function of the victim. That is the function of the prosecutor. The third function is to amend, because through punishment the person can be rehabilitated and be part of the social fabric. That is also a part of public order. The last function of punishment is the Christian function, is expiation. That is obviously not within the scope of the victim's role. Your Honors, what do the victims ask for? What do they expect the lawyers to represent for them? To tell the truth, some will never forgive. They reflect Kelevich's thought in saying that forgiveness is death. Others will forgive. Perhaps some victims would like the accused to be killed, while others want to be locked up for a while, and others want different kinds of punishment. This cannot be quantified by a counsel for the victims, because quantification establishes limits. And I'm concluding now. But our role is to work for the civil parties. And because through these proceedings, we transcend the quantification of a sentence.
Thank you very much, Maitre Sieur. Do any other civil party lawyers wish to comment? And remember, I said about 2 minutes. Madame Jacquin.
Oui, Madame la Présidente.
Ms. Jacquin, very briefly, Your Honor. I think we must consider what has been said on both sides with regard to the practice of civil parties before French courts. I would like to say that the civil parties participate in the prosecution beyond what is done in this court, because in French courts, the civil party is a witness before become a civil party. This has not been adopted here to make it easier for these hybrid courts to operate and to avoid difficulties with regard to the principles. Civil party lawyers express all the difficulties and sufferings felt by the civil parties, but although the civil parties do not require sentencing, they may try to express how the sentencing should be designed. So in restricting the civil party, we should not prevent the civil party from expressing himself or herself with regard to what will come before. We also like to say that in this court, unlike in other courts, there is no financial compensation or damages. There is a request for collective reparation. And I think that the civil parties might have something to say about that later. Thank you.
Thank you very much, Ms. Jakan. Ms. Studinsky, you indicated a desire to speak earlier, and you can be succinct too. Thank you.
Thank you, Your Honours. I would like to refer first to my long and rich experience in a civil law system where civil parties can perform broad rights. I also would emphasize that this court, the ECCC, is unique, and of course we might, if there is no matter dealt with in the rules or the CPC, refer to international or maybe to national practice, but I think this court is unique and should find its own way how to deal with rights of civil parties. To give you, however, a short introduction how different, and it is different, to the French system, civil parties are allowed to act in another civil law system. In Germany, they are allowed to perform a lot of rights, and in addition to the French system, they are allowed to express their views on the penalty on the sentence. They are not obliged, but they may do so. Their rights are limited insofar that they are not allowed to appeal a judgment only because they do not agree with the sentence. I would like to outline some arguments here in our unique situation in Cambodia, in a Cambodian court, and looking what are the rights of civil parties, that is supporting the prosecution and seeking reparations. Supporting the prosecution includes, of course, contributing to the mitigating and aggravating factors. That means the civil parties are allowed to introduce such facts which influence directly the sentence at the end. And therefore, it is logical if they are allowed to add such facts in different manners and introduce this into the proceedings, that they, of course, should be allowed to express their view on the sentence. And I do not agree with the defense saying that this means like, or going back, it is a revenge. It is not a revenge. It is a full participation in the proceedings, and part of the proceedings is finding the sentence. And as they support, as the rules outline, they are, of course, allowed to express what they find on this issue. And otherwise, as we find no restrictions in the Criminal Procedure Code of Cambodia restricting civil party rights in this regard, this respect, so as the law does not mention any restrictions in this respect, of course, it is included and part of their rights of full participation. And therefore, I think if an expert should be heard, I will not object to this proposal by the defense, but of course it should an expert who is able to refer to different civil law systems, and as I have shown, the French system is only one of them, and obviously the rights of civil parties and the extent of the rights is different. And so I might be the French educated Mr. Ballantyre may be very familiar with the French system, but not so familiar in with other law systems or civil law systems. So I suggest to call an expert who can cover all systems to contribute to resolve this question. Thank you very much.
Thank you, Ms. Strudinsky. Any other civil party lawyer? Yes, Mr. Hong. Hong Kim-sun? Yes.
Mr. Hong Kim-sun. Thank you, Your Honor. In my point of view, in the name of the civil party, I am quite familiar with the roles of the lawyer to represent victims who are civil parties in case 001 and 002. I do not intend to challenge this any longer concerning our support for the witness list, whether they are essential or not. But as lawyer Francois who already mentioned, and as reiterated by Mrs. Strudinsky, that these extraordinary chambers in the courts of Cambodia established through the agreement between the United Nations and the royal government of Cambodia, and so far there are public documents to prove that the procedures to be applied in this court is based on the Cambodian criminal procedures. So Article 12 of the agreement states that the procedures must be compliant with the Cambodian procedural system. So only when there is any uncertainty concerning the interpretation of any related national laws, that the international guidance should be sought. So in these internal rules of the Rule 23, it is regarded as a principal criminal procedures to be applied in the whole court. So the term civil parties in this case, of course, they are derived, or they derive from the victims, and they have to be represented according to the law. According to Criminal Procedural Code, Article 3 to 6 of the civil parties who are represented have the right to address the court. So here the rule says the presiding judge shall listen to the statements of civil parties. So as the civil parties, we know the roles, our roles very clearly. So when we would like to submit any documents to be included in the case file, and that we need support from the President, is to make sure we can support the prosecution so that we can bring inculpatory evidence against the accused. So as a civil party lawyer and like our colleagues, our obligation here is not to compel the court to press any, to sentence the accused person, but we follow internal rules, Rule 23. We, the civil parties, are victims. So we are not here only to observe the hearing whether the accused is sentenced or not, and that we only seek reparation. And we already learned that there would not be any individual reparation. However, the rule states clearly the rights of the civil party, and whether these rights are accepted by the court or not, I think it will be left to the court to make a decision. So I would like the court also to give opportunities to the civil parties to address the court by expressing their sufferings and requests. Thank you very much.
Thank you, Mr. Hong Kun-sun. Now, the co-prosecutors indicated that they wish to address the court on this matter. They will, of course, be extremely succinct. Thank you. Ms. Che Liang.
The co-prosecutor Che Liang. Your Honor, thank you. Through the discussions and remarks on this in this context, it is my opinion that the national prosecutor would like to talk about the national laws that has been implemented and is enforced so far. But before we talk about the national procedures and the law, we have to think that this court is a special hybrid court. First, as the lawyer Hong Kun-sun said, we have to apply the Cambodian laws. If it's not, there is a gap in the Cambodian law, then we will apply the international law. So in general, we think that this court is not a fully national court, because this victim unit is not an office, it's not an independent office, and that is not a part of the national law. However, the creation of a separate independent office, as stated by the lawyer, is based on the victims. So how the civil party lawyers and the civil parties play in this role? I agree that the trial chamber needs to consider the Rule 23.1. According to our understanding, is that it is clear that first, whether they are allowed or recognized by the trial chamber to be the civil parties to participate in the hearing. Secondly, whatever they do is in order to support the prosecution by the prosecution office. So whether what they do is to support the charges made by the prosecution is their role. Hence, they have to seek out the witnesses in order to find inculpatory evidences for the accused, to find the guilt of the accused in order to seek for reparation, which is the last intent that they have stated in Rule 23b. This is a specific characteristics for the civil parties. So, whether they arise to express their opinions in the court during the proceeding, even in the national law, it is not prohibited. However, at the end of the trial hearing, usually the trial chamber asks the civil party on whether they have any proposal for the trial chamber to consider. They are not limited in the expression of their opinions. We all know that first they would like to seek their reparation. However, they might also seek for the sentences to be imposed on the accused. So the trial chamber has to consider whether their speech or remarks has any value. We also have to consider the differences between the roles of the prosecution and the roles of the civil party. We have to think, although their remarks on the sentence of the accused is not their obligation. However, this is their right to express their opinions. And the role of the prosecution, or the co-prosecutors in this case, it is our obligation, it is our role, and I agree, because as the co-prosecutors, we work for the benefit of the victims, for the benefits of the public. So we have to consider the involvement and the limit of the involvement of the accused. And it's us to seek the sentence. And they have the right to express their opinions, and the obligation of the prosecution is different. This is what I want to clarify. What we applied in the Cambodian law. And we have our law clearly stated on this specific point. Also, you can have a look at the Rule 23.A and B. And I would like to seek the permission to ask the trial chamber to seek and to look into this rule. And if there is any disagreement on this issue, it is clear to refer to this particular rule on any controversial witness or experts to be summoned. And we have to bear in mind that this is not a fully national court, this is a hybrid court. So then the accused side can also seek experts to provide exculpatory evidence to support their claims. And the prosecution have the right to seek the inculpatory evidence to support their claims for the prosecution. So it is at the discretion of the trial chamber to decide which witness or experts to be summoned. Thank you.
Thank you very much, Ms. Che Liang. Mr. Khan, do you wish to reply?
Your Honour, I'm most grateful.
Madame le juge, merci infiniment de me donner cette occasion de prendre la parole.
Sorry, Your Honour, I was getting French translation. Your Honour, the first observation I will make is that this particular submission was precipitated not only upon a public and confidential filing that was put in by Civil Party Group Number 1, but of course by the submissions by my learned friends for the defence and for the Fourth Civil Party. They have been given two opportunities in closed session and in public session to ventilate their views, and there's been similar submissions. Your Honour, I am most cognizant, I am most aware of the 5-minute parameters, but it does appear that not all of us have been precise in keeping with those limits, and I would ask in advance for Your Honour's indulgence if I stray a little bit beyond those 5 minutes. Your Honour, I think it's only fair that as the lead counsel of the Civil Party Group 1, representing about 40% of all civil parties in this case, that it's only right and proper that we be entitled to address relevant submissions before Your Honour.
Yes, Mr. Khan, you may have a little extra time, but please try to keep it within a reasonable period, because we don't have the rest of the morning for this matter. Thank you.
I'm most obliged, and I have the point. Your Honour, my learned friend Mr. Sir for the Fourth Civil Party stated in closed session and again in public session that the civil parties are united. I venture to say that all parties in this court are united in relation to achieving justice, and I would extend that very freely to my learned friend for the defence and my friends for the prosecution. But of course, it needn't be a matter of great friction or controversy if independent counsel have different views as to how justice can be most effectively and properly achieved. It is the role of the bar to make submissions, and of course it is entrusted to your honours as guardians of justice to decide how justice will be done in this case. So there is clearly a disparity in the views expressed between the civil parties and also other protagonists in this court. There seems to be a clear identity of view, understandable perhaps from the civil law tradition and the country they emanate from my learned friend Mr. Sir for the Fourth Civil Party and my learned friend Mr. Roux for the defence. However, the starting point must be the law, the object and purpose for which this court was established. Reference to Cambodian law is correct. It is the foundation. It is the starting point. And without the legislation of Cambodia, of course, this court would not have existed. But there are distinctions, there are unique characteristics that make this court different. And the fact that this is not Paris, this is not France, this is not a clear inquisitorial system, is made patently obvious in the rules that guide your honours. Rule 21 makes it clear. Rule 21A, proceedings shall be fair and adversarial. So, Your Honours, it's clearly a mix of systems that have been moulded together to do justice. And as a common law lawyer, I am in the rather ironic position, but a position that I quite enjoy, I must confess, that I am seeking to extend victim participation beyond those lawyers whose country is the birthplace of this concept. Your Honour, as a matter of law, Rule 21(3) is also an important starting point, and it is clear that civil parties may participate in criminal proceedings. It is my submission that, given that civil parties are parties of equal standing to my learned friends for the defence and my learned friends for the prosecution, the presumption must be that the extent of submissions must be identical and equal to the participation allowed to the prosecutor and the defence, unless expressly circumscribed. That is my first point. The fact that this is clearly a legislative requirement in the rules is perhaps borne out by just one example, Rule 82(5), and that is a rule that limits certain rights of appeal to the prosecution and to the defence. There is no rule at all before your honours. And of course, my learned friends, Mr. Roux and Mr. Sir and others were silent in my respectful submission on any law that would contradict my primary submission. There is no rule cited that prohibits civil parties calling evidence of the nature that we intend. Your Honours, what is the evidence? They are experts. Two experts that we propose to speak on the issue of reparations. One international and one that can speak to the Cambodian particular issues. Two experts on sentencing, again international and the Cambodia context. And one leading expert also on the issue of harm and trauma. This is relevant evidence. But, Your Honours, again, I do not see a need for undue controversy, because all we are doing under 80 bis is proposing. We are proposing these witnesses to Your Honour, and we say that they will provide relevant and coherent and probative evidence that will assist justice being done. Your Honours, if evidence is put forward by any party, Your Honours are not bound to accept it. Your Honours can disregard it. Your Honours can dismiss it. Or Your Honours may accept part of it. So, Your Honours, simply by allowing evidence to be called does not cause any injustice to any side whatsoever in my submission. Your Honours, the court, the chambers of this court made it clear in the prosecutor and Yang Seri directions on unrepresented civil parties' rights to address the pre-trial chamber in person, which was a decision of the 29th of August of last year at paragraph 5, made it clear that a victim's interest in participating in pre-trial proceedings stems from two core rights: the right to the truth and the right to justice.